Good evening. My name is Scott Dirks, and I'm the municipal judge for the city of Stoughton and the towns of Dunkirk, Pleasant Springs, and Rutland. The city of Stoughton will appear in all matters this evening by Attorney Kieran O'Day. And before I begin calling cases, I want to go over some of the procedures we'll follow, as well as some of your rights as defendants. That information was also made available to you on the sheet that was by the door before you came, as you came in the courtroom. First, please turn off your cell phones. Secondly, if you're wearing a hat, please take it off. This is a court of law. Second, this hearing is for initial appearances on the citations you received. This is not the time for a trial or telling me your side of what happened. When your case is called, please come up to the podium in front here and remember to speak clearly. These proceedings are being recorded, so you need to answer questions verbally and not by simply nodding or shaking your head. Tonight, I'll ask you to enter a plea to the citation you were issued. Your plea options are guilty, not guilty, or no contest. A plea of guilty means you admit you did whatever it is you're charged with. A plea of not guilty means you want to contest the charges against you. A plea of no contest means that while you do not admit doing anything unlawful, you do not wish to contest the matter. In many cases, Mr. O'Day will be in a position this evening to resolve your case right here tonight. If you do arrive at such an agreement, you should enter a plea of guilty or no contest. Either way, guilty or no contest, I must find you guilty. I'll then review the facts of your case to see if there's a factual basis for accepting your plea, and we'll give you an opportunity at that point, if you wish, to tell me anything you feel is relevant to my decision. I'll then decide what the sentence in your case should be. In almost all cases, I will order you to pay a forfeiture, which is a money penalty, like a fine. It may be anywhere from $20,000 to $10,000, though the vast majority will be in the range of $50 to $200. I am also required to impose court costs, which will increase the total amount you must pay. I'll automatically give you 30 days to pay your forfeiture, but if you think you'll need more time than that, please let me know right away, and we'll set up a payment plan. Failure to timely pay your forfeiture can result in suspension of your driver's license or referring the matter for debt collection. If you plead not guilty to the charges against you, I'll schedule your case for a pretrial conference over the phone with the city attorney. At that time, you can discuss your case with him and see if your case can be resolved without a trial. If it cannot be resolved, I'll schedule a matter for trial. You do have the right to have an attorney represent you in your case, but you must hire that attorney on your own. The public defender's office will not represent you. You also have the right to ask me for a continuance of your case if you need to consult with an attorney or for some other reason. If you are charged with operating while intoxicated or some related offense, you have the right to a jury trial in circuit court in Madison. However, you must post jury fees within 10 days of the date you enter your plea. Trials on all other offenses will be heard by me. You will have the right to appeal any decision that I make in your case. Those of you who are charged with a traffic offense should bear in mind that in addition to having to pay a forfeiture if found guilty, the Division of Motor Vehicles may also impose demerit points against your license. If 12 or more points are assessed against your license in any 12-month period, your driving privileges will be suspended for a period of time. If you hold a probationary license, those points may be doubled. Finally, if your address changes at any time while your case is pending, you must notify the court in writing within 5 days of such a change. I'll call the first case, which is City versus Friedenberg. Fredenberg, thank you. Come on up. Yes, ma'am. Ms. Fredenberg, you are charged with retail theft. That means that you intentionally took and carried away without attempting to pay for it merchandise held out by a merchant for resale. Do you understand the nature of the charge against you?
Yes.
I can also inform the city that the victim in the matter is not making any request for restitution. Does the city have an offer for the defendant this evening?
Not at this time, Your Honor.
So, Ms. Fredenberg, you have a couple of choices here. If you plead guilty or no contest tonight, I'll find you guilty. In all likelihood, I'll impose a forfeiture of $187, including costs. On the other hand, if you want to have an opportunity to discuss your case with the city attorney and see if it can be settled short of trial, I'll let you do that, but you should then enter a plea of not guilty, and we'll schedule the matter for a pretrial conference over the phone. How would you like to proceed?
Guilty.
You understand that if you plead guilty, I must find you guilty.
Yes.
All right, I am reviewing the police reports for a factual basis. I do find a factual basis for your plea, and I will accept it and find you guilty. Is there anything you want to tell me before I pass sentence?
No.
And what is the city's recommendation with respect to sentence?
Forfeiture in the amount stated on the citation.
I will accept the city's offer. I will impose a forfeiture and costs totaling $187. Ms. Fredenberg, do you need more than 30 days to pay that?
No.
All right. Hang on, we'll give you a copy of the judgment. You should take that with you, and that will include information on how you can pay your forfeiture.
Okay.
Any questions?
No.
Okay, have a good evening. City versus McCursey. Did I say that right?
Yes.
Okay. Oh, shoot. All right, how do I bring it back?
I know, it's always a process. Always just hit that back arrow, in my opinion.
Oh, sorry.
Oh, it's, I can't see, is it right? I need to be able.
Citation data for court?
Yeah.
Okay.
No, I think that's wrong. It has the date on it.
Oh.
No. I don't want to close this out. Where is that X? That's, every time it seems different. Okay.
Mm-hmm.
Open folder, dispatch. I have to come over here to see.
Sorry.
The print is so small. Adult court. Oh, okay.
Tell John I need a different computer.
Yeah, well, and I tried to make it bigger. Oh, sorry. Okay, so McCursey.
I can find
Okay,
that.
all right.
Thanks. All right, sir, you are charged with, well, let me go back. Your last name is spelled Mckersie,
Correct.
and you still live on Greystone Circle in Middleton.
Yes.
And you are charged with underage drinking or possession of alcohol. That means that you were either drinking or in possession of alcohol, and that at the time you did so, you were under the age of 21. Do you understand the nature of the charge against you?
Yes.
Does the city have an offer for the defendant?
The city will offer to have the defendant do an alcohol and other drug assessment within 90 days, and upon successful completion, reduce the forfeiture to 0.
All right, so Mr. McCursey, what that means is that if you plead guilty or no contest tonight, I would find you guilty, but I'll withhold passing sentence. And I'll keep the case open for 90 days for you to do an alcohol and other drug assessment and comply with any treatment that may be recommended as a result of the assessment. If you do that and provide proof to the court or the city attorney's office within 90 days of today's date that you've done that, then when I next call your case, I'll impose no penalty. The conviction would stand, but you wouldn't have to pay anything. Do you understand the nature of the offer?
Yes.
What would you like to do tonight?
Plead no contest. Boy.
You want to do the treatment?
Yeah.
Okay. Give me a second here. All right, I do find a factual basis for your plea, and I will find you guilty. Mr. McCursey, I hope that when you do the assessment that you'll get something out of the process that will ensue, because I'm looking at the police report, and that was a fairly high blood alcohol concentration. You're only, what, 17?
18.
18? Okay. That's pretty drunk for somebody your age especially. So we're going to give you information on how to do the assessments, as well as a copy of the judgment. You should take those with you, and I would suggest you sign up for that assessment right away. You can do it online if you want. So again, I'm finding you guilty, but I'm not imposing any penalty at this time, and we'll recall this case in 90 days for me to review what you did or didn't do, okay?
Thank you, Your Honor.
Any questions?
No, Your Honor.
All right, thank you. You have a good evening. Lisa Hubrid, did I say that correctly, ma'am? Okay. I don't see you back at all.
Either. I'm trying to close this side bar and see if that makes it appear. Why? That's unbelievable. And so every time to have to close this out, there's
No,
a back
that's
button.
nuts.
John is here, I'll get him, but let's just close
Yeah.
it out. Oh,
Okay.
no.
No rhyme or reason. Okay. Ma'am, is your last name spelled Huberd?
Yes,
And do you still live on Charles Lane in Stoughton?
yes,
Ma'am, you're charged with being a parent or guardian liable for the truancy of a child who is either your child or for whom you are their guardian. Do you understand the nature of the charge against you?
yes.
Does the city have an offer for the defendant?
Not at this time, Your Honor.
So, ma'am, you've got a couple of choices. If you plead guilty or no contest tonight, in all likelihood, I would find you guilty, and in all likelihood, I would impose a forfeiture and costs totaling $691. On the other hand, if you want to try to discuss the case with the city attorney's office, I'll give you time to do that. And if that's what you want to do, you should enter a plea of not guilty tonight.
Okay, I would like to do not guilty. I would like to discuss my case with,
All right, very good. We'll give you notice of the pretrial conference. That'll include Mr. O'Day's phone number so you can call him.
okay,
It's very important that you make that call on the date and time scheduled, because if you don't, Mr. O'Day and the court will assume that you are no longer interested in settling the matter, and instead, you'll be found guilty and ordered to pay a forfeiture of $691.
Okay,
Okay?
okay.
Any questions?
No,
All right, thank you. You have a good evening.
thank you.
Why is this not
Oh, at the top, he has.
Oh, I see.
Individual files for.
Got it.
For each citation, so
Yep.
these are the
Logan Conway.
requests for restitution that we've received so far.
Okay. Sir, are you Logan Conway?
Yes, I am.
And that's spelled Conway?
Yes, Your Honor.
And do you still live on County Road N in Stoughton?
That is correct.
Sir, you're looking at several charges tonight. Operator of a motor vehicle while failing to wear a seat belt. You've got 1, 2, 3, 4, 5 counts of criminal damage to property. That means that you caused damage to another person's property intentionally without that person's permission. Do you understand the nature of that charge?
Yes, Your Honor.
You're also charged with shooting or throwing missiles at another person's property. Do you understand the nature of that charge?
Yes, Your Honor.
You're also charged with retail theft. That means that you took away, without attempting to pay for, merchandise held out by a merchant that's held out for resale. I can also state that there are at least 2 requests for restitution at this time. Total requested by the victims so far, because we may be getting more, is in excess of $4,000. Does the city have an offer for the defendant tonight?
Not at this time, Your Honor.
Mr. Logan, how do you wish to plead?
I plead not guilty to the missile and the other high count on there. I forgot which one it was. But then I plead guilty to the retail theft and the seatbelt violation.
All right, what I'm going to do is I'm going to enter a plea of not guilty on your behalf on all of the citations. It'll just be easier for you in the city to try to work something out if all the cases have the same status. We will provide the city with copies of the restitution requests, because I'm assuming that that probably will be a germane part of the conversation. We'll give you notice of a pretrial conference, which will be on September 10th, and that'll be over the phone
340,
at 3:40 in the afternoon. Does that work for you?
Yes, Your Honor.
Okay.
I would prefer just to send him that notice.
Okay,
because it
no, that's
will
fine.
take
All right, we'll have to mail notice of the pretrial for you. That'll include Mr. O'Day's phone number. Okay?
Yes, Your Honor.
Any questions about anything?
No, Your Honor.
All right, thank you then. We'll also mail copies of the restitution requests to you as well, so that you can discuss those with Mr. O'Day. Okay?
Yes, Your Honor.
All right. Thank you. Have a good evening.
You as well.
City versus calendar. Damn it.
See it, but I don't understand.
No, I don't either.
Come on. And it's dispatch. And then the court date, I can't find, there's hearings and then just adult court.
One
Is
up.
that-
There you go.
Okay. Come on. Really? Okay.
You wouldn't believe that we've been doing this for a very long time. So, sir, are you Julian Callender?
Yes, Your Honor.
Did I say your name correctly?
Yes.
All right. Mr. Callender, do you still live on Roby Road in Stoughton?
Yes, Your Honor.
You're charged with criminal damage to property, meaning that you caused damage to another person or entity's property intentionally and without that person or entity's permission. Do you understand the nature of the charge against you?
Yes, Your Honor.
Does the city have an offer for the defendant?
Based on the school's recommendation, the city will offer a $0 forfeiture.
So in other words, sir, if you plead guilty or no contest, the city would recommend that you be ordered to pay no penalty. Do you understand that?
I do, Your Honor.
You should also understand that I'm not bound by the suggestion of the city. If I felt it was appropriate, I could order a fine of $187, including costs. Do you understand that?
I do, Your Honor.
How would you like to proceed tonight?
I plead no contest.
Do you understand if you plead no contest, I must find you guilty?
I do, Your Honor.
All right, I've reviewed the police reports. I do find a factual basis for your plea, and I will find you guilty. The city's recommending no penalty. Is there anything you'd like to tell me about this case before I pass sentence?
No, Your Honor.
You sure?
No, Your Honor.
All right. Why did you do this?
I thought it was funny, but in the end it was a
But what?
poor... I thought it was funny, but in the end it was a poor decision that I made.
At the time this occurred, you were 17?
No, Your Honor.
How old?
18.
Okay. You understand this could have been an arrest and a referral to criminal court in Madison on a charge of criminal damage to property. Do you understand that?
I do, Your Honor.
You could have been looking at a fine of up to $10,000 and 9 months in the Dane County Jail. You understand?
I do, Your Honor.
Okay. I have read an email from the high school that says that you have paid restitution, that you've apologized to the schools at least, and based on that, I will accept the recommendation from the city and I'll find you guilty but impose no penalty. But understand, you caught a break here. Have you graduated from high school then?
I have.
And what are you planning on doing now that you've graduated?
Attending Milwaukee for 4 years.
UW Milwaukee?
Yes, Your Honor.
Okay, good. Things could have turned out a lot differently for you. You could be sitting in the Dane County Jail instead of starting school in the fall. I certainly hope that you're not going to do anything like this again.
I will not, Your Honor.
Okay. Do you have any questions about anything?
I do not.
All right, then. With that, you're free to go.
Thank you.
Thank you. City versus Kelly Starks.
Sorry.
Ms. Starks, is your first name spelled Kelli?
Yes,
Last name Starks?
that's correct.
Do you still live on Eisenhower Road in Stoughton?
Yes,
Ma'am, you're charged with failing to stop for a school bus after it had made its stop indications. Do you understand the nature of the charge against you?
Yes, I do.
Does the city have an offer for the defendant?
No, Your Honor.
So, Ms. Starks, if you plead guilty or no contest tonight, in all likelihood, I would find you guilty and impose a forfeiture and costs totaling $691. The Department of Motor Vehicles will also assess at least 4 points against your driver's license. On the other hand, if you want to have an opportunity to discuss the case with the city attorney's office and see if you can resolve it without a trial, I would give you an opportunity to do that. You should then plead not guilty, and I'll schedule the matter for a pretrial conference over the phone. So how would you like to proceed?
Sorry, this is new to me. In order to review it, the circumstances, would I have to plead not guilty?
Well, if you want to review the circumstances with the city attorney, with Mr. O'Day, and see if the two of you can come to a resolution without a trial, you should plead not guilty.
Okay, I would like to do that, please. Yes, please.
Yeah, that's fine. I'll enter a plea of not guilty for you then. Can we give her notice today?
Yes.
Okay, and we'll give you notice before you leave. That'll be on the phone, September 10th at
3:50.
3:50 in the afternoon. Does that work for you?
Yes, I can make it work.
Okay. Hang on, and we'll give you that written notice, and that'll have Mr. O'Day's phone number.
Thank you.
You're welcome. Do you have any questions about anything?
I don't.
Okay.
Thank you.
All right, have a good evening.
You too.
Thank you. City versus Gebhard. Gebhard, I'm sorry. Did I say that did I say that right?
The second time you did, yep.
Gebhard, got it. Sir, you are cited, well, excuse me. Do you still live on Milwaukee Street in Stoughton?
That's correct.
All right, you're cited for operating a motor vehicle at an unreasonable and imprudent speed. Do you understand the nature of the charge against you?
Not really, actually.
Okay? You may or may not have been speeding, that is, exceeding the posted speed limits, but whatever speed at which you were operating, given the facts, and I don't know what those facts are, the officer who investigated determined that you were driving at a speed that was unreasonable and imprudent under the circumstances. I don't know what the facts of the case are. I'm just telling you that's what you're charged with doing. Do you understand the nature of the charge?
I guess I do after you explained it, yep.
Okay. Does the city have an offer for the defendant this evening?
Not at this time, Your Honor.
So, Mr. Gebhardt, if you plead guilty or no contest tonight, in all likelihood I would find you guilty. In all likelihood I would impose a forfeiture and costs totaling $136, though I would listen to anything that you have to say about what you think should happen with the case before passing sentence. On the other hand, if you want to have an opportunity to discuss the matter with the city attorney's office over the phone and see if you can get the case resolved without a trial, if you do get it resolved, you probably won't have to come back to court. And if that's what you want to try to do, you should plead not guilty, and I'll schedule the matter for a pretrial conference over the phone. So how would you like to proceed?
I guess I'm not sure. Is what you're saying is if I plead guilty, you'll hear what I have to say, but still find me guilty?
Yes,
And just maybe lower the penalty or something of that issue?
possibly.
So it sounds like, do you have control over the points? It sounds like the DMV does. So in
I
order
have
to
no
get,
discretion over that at all.
so in order to get rid of the points, I would have to be found not guilty.
Yes, or perhaps you could arrive at an agreement with the city attorney's office where you plead to an amended charge that doesn't have any points. That's a possibility. I'm not saying that's what's going to happen, or that I would agree to it, or that the city would even offer it, but that's possible to do. If you want to have a trial, we can have a trial. I don't have a problem with that.
Right, but not right now.
No, it won't be tonight. It would probably be this fall sometime.
Okay. I guess not guilty. I guess I don't have a choice.
I think that's wise. So I'll accept your plea of not guilty. I'll schedule this for a pretrial conference over the phone, September 10th, still, at 4 p.m. Would that work for you?
I don't know. How would I know? I don't have my phone. It's off. How
Well,
could I-
when do you normally work, I guess, is the question.
I work like double shifts, so.
I'm sorry?
I own my own business, so I'm
Oh.
basically always working, so.
Yeah.
I mean, I could check my phone, but it's off. So if you guys want to schedule something, I guess you'll just have to go ahead and I'll just have to make it.
Why don't you just check your phone quick? It'll save us all time.
So September what?
10th at 4?
4 p.m.
4 p.m.
What day is that?
That'd be a Wednesday.
So while my phone starts up, can you help me understand the charge a little? So if the conditions were fine, how could I be doing unreasonable and prudent speed?
I don't know. I don't know what the facts are. I could tell you as a hypothetical that if you were driving on an icy road
Right.
in the middle of a blizzard at 25 miles per hour in a 25 mile per hour zone, that might still be unreasonable and imprudent given the conditions. Do you
But prob-
understand what I'm saying?
but
You're not
probably-
speeding, you're not exceeding the
Right.
posted limit, but you're going too fast for the conditions.
But probably not in July.
No, no.
Okay.
That's why I use that as a hypothetical instead of something else. So does September 10 work for you?
Yes.
Okay. That's what we'll do then.
Do you want to file any supporting docs that I brought with me today, or is that not appropriate?
No, don't file those with me. If it's helpful for your discussion with Mr. O'Day, he could tell you how to email those, scan them and email them to him.
Okay.
Okay?
Sure.
Mr. O'Day, is your email on that notice? I don't think it is. Okay. All set? Any questions?
Nope.
Okay, then
Thank
you
you,
have
sir.
a good evening. City versus Brabender. Sir, did I say your name correctly?
It's Brabender.
I'm sorry?
Brabender.
Brabender? Thank you. Do you still live on Barber Drive in Stoughton?
Yes.
I'm sorry, but you're going to have to speak up a little.
Yes.
Okay, thank you. You're charged with criminal damage to property. That means that you intentionally damaged the property of another person or entity without that person or entity's permission. Do you understand the nature of the charge against you?
Yes.
Does the city have an offer for the defendant this evening?
Yes, Your Honor. Similar to the prior defendant, the school informed the court that this defendant has completed restitution and community service, so we would adopt the school's recommendation of no fine.
Sir, what that means is that if you plead guilty or no contest tonight, the city is recommending that although the conviction would stand and remain on record, they're recommending that I impose no sentence. Do you understand what the city is offering?
Yes.
How would you like to plead tonight?
No contest.
Do you understand if you plead no contest, I must find you guilty?
Yes.
I've reviewed the police reports for a factual basis. I do find a factual basis for your plea, and I will find you guilty. So, Mr. Brabender, similar to your co-defendant who was here earlier, first, is there anything you would like to tell me before I pass sentence?
Yeah, the past couple months I've been struggling with some mental health issues, but I've been talking to a therapist and on some medication, and after this incident, I went back and talked to them both and made some changes, and I feel like it's really helping.
Okay, that's good. Did you graduate?
Yes.
What are your plans now that you've graduated?
I'm going to go to University of Edgewood next fall.
Oh, very good. Any idea what you might major in?
Business.
Okay. Well, you probably heard me say what I did to your co-defendant. This could have turned out a lot differently.
Yes.
You could be sitting in the Dane County Jail instead of going to college this fall. All right, I have reviewed an email from the Stoughton High School. They tell me that you and your co-defendant have paid restitution, done community service. I hope you apologized to the school at some point.
Yes.
Okay. Given all of that, I will adopt the city's recommendation and I will find you guilty, but I will impose no penalty. We'll give you a copy of the judgment. You should keep that for your records. And when I say this remains on your record, what I mean by that is there's no public record that you can search online for this conviction. So it won't show up in CCAP.
Okay.
But our records will show that this happened. So if you end up back in front of me again, that may have some bearing on what happens next time around.
Okay.
Okay?
Mm-hmm.
All right. I'm glad to hear that you're getting treatment. I hope that goes well for you. Any questions about anything?
No.
All right. Thank you. Then you have a good evening.
Thank you.
City versus Pamela Smith. You're Ms. Smith?
Yes,
And do you still live on Geeler Drive in Stoughton?
I do.
Ma'am, you're charged with speeding, specifically that you were traveling at 35 miles per hour on a public highway with a posted speed limit of 25 miles per hour. Do you understand the nature of the charge against you?
I do.
Does the city have an offer for the defendant this evening?
Not at this time, Your Honor.
So, Ms. Smith, you have a couple of choices. If you want to have an opportunity to discuss the case with the city attorney, you should enter a plea of not guilty, and I'll schedule the matter for a pretrial conference over the phone. On the other hand, if you plead guilty or no contest tonight, I will find you guilty, and in all likelihood, I would impose a forfeiture and costs totaling $98.80. That's the minimum that I can impose. So what would you like to do tonight?
No contest.
Okay, if you understand, if you plead no contest, I must find you guilty.
I understand.
All right, I've reviewed the police reports. I do find a factual basis for your plea, and I will find you guilty. What's the city's position with respect to penalty?
As stated on the citation, Your Honor.
And Ms. Smith, is there anything you'd like to tell me before I decide on sentence for you?
first time I've ever been stopped by a Stoughton cop, but he was very courteous, and he knew where I was going. And it was in the morning. I was going to the Methodist food pantry to deliver baked goods. But I didn't obey the sign. It's given me pause when I
Okay.
drive the streets of Stoughton.
So this was on Jackson at Nottingham. Yeah, as you know, that's a residential neighborhood. There are a
I'm
lot of
aware-
kids that
I'm
live
aware
there.
of that.
Yeah. And from what you've said, it sounds like that's a route that you drive with some frequency, so,
Twice a week.
right. All right. I really don't have much discretion as far as disposition other than to impose $98.80. As I said, that's the minimum.
That's fine.
Okay.
What are my points?
That's a 3-point violation.
Okay.
No, I take that back. I'm going to find you guilty of speeding by 9 miles per hour over the posted limit. That's a 3-point violation. 10 over is a 4-pointer. So that'll save you a point.
Appreciate it. Thank you.
Sure. Your insurance rates are probably going to go up for a few years.
I know.
Okay. Well, tell everybody else, too. I mean, that this is what happens when you're speeding. It can get expensive. Sorry to do that to you.
okay.
Do you need more than 30 days to pay that?
No.
Okay. So we'll give you a copy of the judgment. That gives you information on how to pay your forfeiture. And if you have no questions, you're free to go.
I can pay downstairs, right? Right now?
Yes. All right. City versus Holly Dunn. You're Ms. Dunn?
Yes.
And do you still live on Mariposa Lane in Madison?
Yes.
Ma'am, you are charged with being a parent or guardian liable for the truancy of a child in your care. Do you understand the nature of the charge against you?
Yes.
Does the city have an offer for Ms. Dunn this evening?
Not at this time, Your Honor.
So, Ms. Dunn, if you plead guilty or no contest, in all likelihood, I will find you guilty. And in all likelihood, I would impose a forfeiture and costs totaling $691. On the other hand, if you want to have a chance to discuss the case with the city attorney and see if this can be resolved without a trial, you should enter a plea of not guilty, and I'll schedule the matter for a pretrial conference over the phone on September 10th at 4:10 in the afternoon. How would you like to plead?
Not guilty.
All right, and does that time for a pretrial conference work for you?
Yes.
Okay. Hang on and we'll give you written notice of that. That'll have Mr. O'Day's phone number on it.
Okay.
Do you have any questions about anything, ma'am?
Nope.
Okay, thank you. Then you have a good evening.
You too, thank you.
City versus Arvold.
If he's found guilty, we have other restitution hearings on August 20th, so I tentatively set this for you
Okay.
to him tonight.
Okay. Sir, is your last name spelled A-R-V-O-L-D?
Yes.
And you still live on South Madison Street in Stoughton?
Yes.
Sir, you're charged with criminal damage to property, meaning that you intentionally caused damage to property belonging to another person or entity without that person or entity's permission. Do you understand the nature of the charge against you?
Yes.
Does the city have an offer for the defendant this evening? I should state, both for the city's benefit and the defendant's, that there is a request for restitution in this matter totaling $5,000.
No, not at this time, Your Honor.
So, Mr. Arvold, here are your choices. If you plead guilty or no contest, in all likelihood, I would find you guilty and impose a forfeiture and costs totaling $187. I would also set the matter for a restitution hearing in August, unless you agree tonight that the request for $5,000 is agreeable to you. On the other hand, if you plead not guilty, I'll schedule the matter for a pretrial conference over the phone on September 10th at 4:20 in the afternoon.
Okay.
How would you like to proceed?
Not guilty.
All right, I will accept your plea of not guilty and schedule the matter for a final pretrial conference over the phone at 4:20 on September 10th, 2025. And we will mail you a copy of the request for restitution, and we'll make sure that we get that to the city as well.
I have a copy. I have it.
Oh, sorry.
I'll give it to him.
Okay, very good. We'll give you a copy of the request for restitution before you leave. Sir, do you have any questions?
No. Thank you.
Have a good evening. City versus, and I know I'm going to say this wrong, McBogey? I'm sorry? Embauge, thank you.
It's okay, everybody does it.
Well, no, people should say your name right, and I'm
okay.
sorry I didn't.
It's okay.
Ma'am, is your last name spelled M-B-O-G-E?
Yes, Your Honor.
And do you still live on Gilbertson Road in Monticello?
Yes, Your Honor.
Ma'am, you're charged with retail theft, meaning that you took property from a merchant that was held out for resale by that merchant without attempting to pay for it, and that you did so intentionally. Do you understand the nature of the charge against you?
Yes, Your Honor.
Does the city have an offer for the defendant tonight? I should state to the parties that the victim is not requesting restitution.
Not at this time, Your Honor.
So, ma'am, if you'd like to have an opportunity to discuss the case with the city, you should enter a plea of not guilty, and I'll schedule the matter for a pretrial conference on September 10th at
4:30?
4:30 in the afternoon. That'll be over the phone. On the other hand, if you plead guilty or no contest tonight, in all likelihood, I will find you guilty and impose a forfeiture and costs totaling $187. How would you like to proceed?
No contest.
You understand, if you plead no contest, I will find you guilty.
Yes, Your Honor.
Okay? Give me a chance to review the police reports for a factual basis. I do find a factual basis for your plea, and I will find you guilty. What's the city's position with respect to disposition?
As stated in the citation, Your Honor.
Okay. Ma'am, is there anything you'd like to tell me about your case before I pass sentence?
No, Your Honor.
Well, why'd you do this?
I've been feeling the pressure. My daughter is about 7, and she just don't understand no, and she will start throwing temper tantrums in the store and doing the most, and I'm struggling to deal with that, and it puts more pressure on me to spend money I don't have. So I've switched to now doing just pickup orders, so I don't even have to take her in the store.
Okay, well, that sounds like a good idea. It may also be that your daughter might need some help. I mean, is there something more going on here than simply a 7-year-old who's being difficult?
I don't think so. She doesn't have her dad really in her life, so it's just really me. So I feel even more pressure to kind of like make up for that she's missing, you know, so.
Are you working right now, ma'am?
I am, yes.
Where do you work?
I am a home nurse for a cerebral palsy patient.
Okay. How much do you make?
About just a little under $17 an hour.
And do you work full-time?
Yes.
So 40 hours a week?
35. They deduct, it's like 7.5 hours a day.
Okay. Here's what I'm going to do then. I'm going to impose a forfeiture and costs totaling $187. How much time will you need to pay that?
I'd say 60 days. Is that fair?
I can give you more than 60 days if you want.
Okay. Let's do 90 then, please. I could do
Okay.
like little payments weekly or
All right.
weekly.
I will order you to pay, let's make it 120. I'll order you to pay $60 per month. And I will order that this be paid by 4 months from now, and we'll have that on the judgment.
Okay.
Yeah, November 14th.
Okay.
Okay. I'm also going to give you a flyer with contact information for the Stoughton Area Resource Team. I would suggest that you give them a call and explain your situation, how you ended up in court here, the difficulty you're having with your daughter. It may be that they could help you find some resources in how to deal with the parenting situation you've found yourself in.
Okay, Your
I'm
Honor.
not saying you're being a bad mom or anything like that, but it sounds like maybe things are getting a little overwhelming at times.
Yes, Your Honor.
Okay. So, okay, $60 a month, payable within 120 days. Any questions about anything?
No, Your Honor.
Okay, thank you then. You have a good evening.
Thank you. You too, Your Honor.
Thank you.
I need to get a paper from you.
Pardon?
Do I need a paper from her?
You got it.
Oh, okay.
That's the judgment.
Okay, thank you.
And that'll tell you how you can pay your forfeiture.
Okay, thank you so much.
Thank you.
I think Wardle, I'm not sure.
Okay.
On there.
Oh, yeah. Well, is it Wardle or Williams?
Did I include? Yeah, it's Wardle.
Okay.
Okay. Mine's a little older version. Oh, what was your name? Cameron Fisher. Okay, you're for 6 o'clock. Okay, perfect. Thank you.
Yep, just have a seat. City versus Wardle. Ma'am, how do you pronounce your last name?
Wardell.
Thank you.
Yeah, it's a questionnaire that she was given.
Okay. Ma'am, you're charged in 2 citations with operating a motor vehicle while under the influence of an intoxicant. I'm sorry, 3 citations. First of all, do you still live on Vernon Street in Stoughton?
Yes.
Okay. And actually, there are several citations here. The first is failure to stop at a stop sign. That means that you failed to stop for a stop sign at an intersection. You're also charged with operating a motor vehicle without auto insurance. Do you understand the nature of that charge?
Yes.
You're charged with being the driver of a vehicle in possession of open intoxicants while operating a motor vehicle. Do you understand the nature of that charge?
Yes.
You're charged with operating a motor vehicle under the influence of an intoxicant while on a public highway. Do you understand the nature of that charge?
Yes.
Is that a yes?
Yes.
And then finally, you're charged with operating a motor vehicle on a public highway with a prohibited blood alcohol concentration, specifically that at the time the breath or blood sample was tested, it showed a breath or blood alcohol concentration of 0.11. Do you understand the nature of that charge?
Yes.
Second, first offense of moving at night.
Okay. Does the city have an offer for the defendant this evening?
No, not at this time, Your Honor.
So, Ms. Wardell, if you plead not guilty tonight, I'll schedule the matter for a pretrial conference over the phone, and at that time you can discuss the matters with the city attorney to see if some sort of agreement can be worked out. You may not have to come back to court if you do that. On the other hand, if you can't get it worked out, then I'd schedule the matter for a trial. Your other choices tonight are to plead guilty or no contest to all or some of these charges, and I would then find you guilty of all or some of these charges, and we would proceed to sentencing tonight. So how would you like to proceed?
No contest.
Do you understand if you plead no, are you pleading no contest to all of these?
Yeah. Yes.
Do you understand if you do that, in all likelihood, I would find you guilty and order fines totaling in excess of $1,000, probably closer to $1,500. Because this is a second first offense, I would also have to order that an ignition interlock device be placed at your expense on any vehicle you own or drive, and that you would have to pay for the maintenance of that interlock device for a period of 12 months. Your driver's license would also be revoked for a period of time, and the interlock device would be installed after the period of suspension is over. So there are a lot of penalties here, is what I'm saying.
Okay.
Are you sure you don't want to have a chance to talk this over with the city attorney?
Yeah, I should.
Pardon?
Yeah, I think I should do that then.
You should what?
Talk it over with them.
All right. I'll enter a plea of not guilty on your behalf on all the citations and schedule this matter for a pretrial conference on September 10th at 4:30. Now, because you're entering a plea of not guilty tonight, if you decide that you want to have a jury trial on these charges, you can do that, but you have to post jury fees in Madison within 10 days of today. So I'm not suggesting anything, I'm just saying that if you do decide you want a jury trial, there's some things you're going to have to do pretty quickly.
Okay.
Okay? So hang on a minute here and we'll give you notice of the pretrial conference. And that again will be over the phone, and that'll have Mr. O'Day's phone number on it.
Thank you.
Okay? You're welcome.
Few minutes here.
And she's got a copy of this?
She does. Yes.
Okay.
Sorry, just a couple minutes.
Nope.
So many of them.
No, it's all right.
Easy way to do it.
Is there anybody else here for a 5 o'clock hearing? Okay. We'll get to you folks in just a couple minutes then.
Here's the big one. That has everything on there for her. That's it, yeah.
Yep.
What we have is 6 o'clock.
All right, before we get to those, with respect to any of the matters set for 5 o'clock that I have not yet called, I will find the defendants guilty by default and impose by way of penalty the amounts that are in the deposit section of the citations that were issued. And then, do you have a copy of the 6 o'clock docket for me?
Hannah will not be appearing, I'll explain that.
Okay, we'll get to it. City versus Cameron Fisher. Do I have his citation?
If you go to that second folder of today's date with hearings, all of
How do I find that?
if you X this out, have to probably start all over, go to that
This?
blue bubble, yes, and then hit open folder at the bottom, and then dispatch, and then you'll see the date and hearings. That's the one, if you open that.
This one?
Right.
Okay, got
And
it.
then- Okay.
All right, Mr. Fisher, are you still living on Hilltop Court in Richfield?
Yes, I am.
And you were cited for speeding at 99 miles per hour in a 55 mile per hour zone. I understand, if I understand correctly, the parties have an agreement to slightly amend the citation. Is that correct?
That's correct, Your Honor.
Okay, I'm not going to put words in your mouth. City, please tell me what the parties' agreement is.
The parties' agreement was to amend the citation down to 30 to 34 miles per hour, which is still a 6-point violation, but it reduces the fine, the forfeiture amount to $1850. And the city has one addition to the offer.
Okay.
Is that the defendant would complete the Alive at 25 course.
Okay. So mechanically, how would we accomplish all of that tonight, assuming I go along with it?
I don't know. I think I have the Alive at 25 schedule up. It looks like the next available course is August 12th.
Okay.
So I would say 90 days to do the Alive at 25, hold it open.
And then do sentencing at that point.
Yep.
Okay.
And this is based on, from what I can tell from the defendant's driving report, this is a first offense for him. 16 seems like an appropriate offer on the city's end.
All right. Mr. Fisher, has the city correctly stated the agreement between you and the city?
Yes. Sorry. Yes, Your Honor.
Okay. I've got to tell you both, I don't have a problem with the amendment that's been offered. And how would you plead to the amended citation?
Could I ask what that means?
Well, right now you're charged with speeding by 44 miles per hour over the posted limit. And the city is asking that the city is moving to change the charge, amend it to speeding by 30 to 34 miles per hour over the posted limit. So how do you plead to that amended charge?
Guilty, Your Honor.
All right. Give me a chance to read the citations here. All right. I will accept the amendment and find you guilty to the amended citation. And I certainly agree with the city's recommendation to do the Alive at 25 program. So I'll hold off on sentencing for 90 days to give you time to do that. But I have to tell you, I'm not really happy about reducing the forfeiture here. You were going 99 miles per hour at night, almost midnight, with a passenger. Who was the passenger?
My best friend.
Okay, and how old was the best friend?
19.
All right, and at the time of the offense, you were how old?
16.
Okay, look, you got a break here. You could have been charged with, assuming there wasn't a crash, you could have been charged with second-degree reckless endangerment of another person's safety. That's a 15-year felony.
I understand.
Even though you're only 16, you could still go to juvenile court, and you could still be locked up in a juvenile prison on that offense. I mean, I know that stretch of road very well myself. It's an area that deer run over all the time. Do you know what would happen if you hit a deer at 99 miles an hour?
Yes, Your Honor.
What's going to happen?
Somebody could get hurt or worse.
Yeah, someone's probably going to die. Why were you going that fast?
I was rushing to get home because I was late.
Well, yeah, what if you got home late because you're in the hospital for 3 months?
I understand. I'm not saying that it was a smart decision. Looking back on it, I regret the decision. That's just what I was thinking in the moment.
Mr. Fisher, that was a really, really bad decision.
I understand.
Whose car were you driving?
It was mine at the time, Your Honor.
Do you still have it?
No, Your Honor. My dad has sold it since.
Pardon?
My dad sold the car since.
How did you get here tonight?
My mom drove me.
Okay. You understand there's an automatic 15-day license suspension as of tonight? So you can't drive any vehicle for 15 days. Who pays the insurance for your driving?
My dad.
Okay. Your auto insurance is almost certainly going to go up a lot, and it will stay that way for at least 3 years, I would guess. But that's between you and your dad, I guess. All right. So I've found you guilty to speeding by 30 to 34 miles per hour over. If you do the Alive at 25 program between now and 90 days from now, I'll consider sentencing at that time. I'll tell you right now that even if you complete that program, I want you to come back here and convince me that $218.50 is sufficient penalty. And I assume you're still on a probationary license, correct?
Yes, that's correct.
Okay, do you understand that if you get, this is a 6-point violation and it'll stay that way, but if you get any other violation while you still have a probationary license, the points will double.
Yes, I understand.
So if you pick up another 6-pointer, it's going to be 12, and then your license gets suspended again. All right. Do you have any questions for me?
No, Your Honor.
All right. We'll give you a copy of the judgment. And I'm giving you notice right now that when we come back for sentencing, I want you here. Okay?
Yes, Your Honor. Thank you.
All right. If you don't have any questions, you're free to go.
Thank you.
Folks, which case are you here for?
Peyton Danforth, 6 o'clock.
Oh, yeah.
We just have to bring proof of
Sure.
completing
City versus Danforth.
Alive at 25.
Did you get anything?
No, he was bringing it to
Oh, okay.
court.
Good.
And then if he does.
Yeah.
Thank you.
Thank you. All right, Mr. Danforth, it looks as though you completed the Alive at 25 program. What's the city's position?
City moves to dismiss.
So ordered. Drive safely.
I'm good?
Yeah, you're good.
Okay. Thank
Hold
you.
on,
Oh,
we'll get a copy.
oh, yeah, wait. We need to give you a copy of the judgment
Just
first.
You can sign that one, and then this is our copy.
Okay, thank you.
Mary, Attorney Orth called or emailed with his
Oh.
phone number, so if you
Okay.
want to call him to do.
Okay, I haven't opened my email. Do you have it?
Yeah. 608-345-8855.
This is Jennifer Weigert.
Right.
The number you have dialed is not in service.
All right, 608.
608-345-8855.
Hello?
Is this Mr. Orth?
This is.
Mr. Orth, this is Judge Scott Dirks, Stoughton Municipal Court. How are you?
Good, Judge. How are you?
Good. I'm going to call City versus Jennifer Weigert. Mr. O'Day is here for the city. You're appearing for the defendant?
That's correct, Your Honor.
All right. Mr. O'Day, what's the agreement of the parties?
The agreement is for the defendant to plead no contest to the OWI, which would impose a $910 forfeiture, a 12-month ignition interlock device, 6-month license revocation, 6 points, and the AODA, and then the city would move to dismiss the PAC.
Mr. Orth, is that your agreement with the city?
It is, Your Honor.
All right. I will find the defendant guilty of operating while intoxicated. I have reviewed the reports, so I do find a factual basis for the plea. With respect to penalty, I guess I have some questions as to why we are deviating from the 5th Judicial District guidelines. It appears to me that there was not a crash on the highway, but the defendant hit a pole at a Quick Trip gas station, may or may not have done damage to the property there. What was the BAC, Mr. O'Day?
I believe.
19?
Yep, I believe
Okay.
that's right.
So it would seem to me that if we follow the district guidelines, this should be $200 to $275. I'm sorry, $200 to $300 plus costs, and an 8 or 9 month revocation. I haven't totaled up the forfeiture, and frankly, that doesn't concern me as much as a very short revocation. Mr. Orth, has your client engaged in any kind of alcohol or other drug counseling?
Yes, Your Honor, I believe she does. I'm out of my office, so I don't have documentation of that at the moment.
Okay. Mr. O'Day, do you know anything about this?
I don't, Your Honor.
Okay, so I guess I'd like to hear first from the city why I should deviate from the district guidelines down to 6-month revocation. And then I'll hear from you, Mr. Orth.
Sure.
Your Honor, from the city's position, looking at Ms. Wiegert's driving abstract, it appears to be her first traffic offense. And from the police report, she was cooperative with police. She completed the field sobriety tests. She agreed to the breathalyzer, and was, again, overall cooperative given the circumstances. So both based on her driving record and the circumstances surrounding the stop, the city is comfortable with the offer of that the parties have presented.
Thank you. Mr. Orth?
Your Honor, a few things. The recitation of the facts and circumstances is correct. As far as hitting the pole at the parking lot, I don't think there's any evidence that there was any damage that I'm aware of. As Mr. O'Day indicated, she's taking responsibility for this incident. She hasn't litigated anything. She was cooperative, respectful throughout her interaction with law enforcement. Obviously, this is her first offense, and Ms. Wiegert is 53 years old, and this is her first, and it's a true first, not a second first. This is a really sole run-in with the law after 53 years. I think that's something to be taken into account. As for the guidelines, in my experience anyway, they generally tend to be applied a bit more loosely to first offenses than, subsequent offenses where, you're evaluating what the appropriate term of jail would be. And part of why this is something that I negotiated on her behalf in exchange for the plea was that she's completed her 6-month administrative suspension, and it was, primarily to spare her the, inconvenience of, going back on an occupational for a month or 2 months, especially where the ignition interclock is being required anyway. It's just going to cost her money and inconvenience with, I don't think, any real public safety interest when you consider that she's going to be restricted to operating a vehicle with ignition interlock, regardless of the length of revocation for, at least 12 months from whenever she is able to obtain a license once the revocation goes through. So I think it's a pretty minor concession in the big picture of things, especially again in first offenses where I think the primary public interest is securing a countable prior conviction, which by entering the plea here, she's, agreeing to that. So I think, I don't think sparing her a month or two of license revocation is a very significant break in the grand scheme of things. So I'd ask the court to follow the negotiated settlement.
Well, first of all, the guidelines I'm referring to are for first offenses. I'm not looking at guidelines for something else. So these are the guidelines. Obviously, they are only guidelines. It's not mandatory on the court to follow the guidelines. I would be more comfortable with this recommendation if I had some kind of proof that she has completed an alcohol and other drug assessment and has complied or is complying with any treatment that's been recommended. I was a prosecutor for almost 30 years and handled I don't know how many drunk driving cases. And it was the norm for defense attorneys to try to get their clients to do that assessment ASAP and get proof thereof to the prosecutor for presentation to the court in support of a downward deviation from the guidelines. So I'm a little bit concerned, Mr. Orth, that you haven't done that. I will take your word as an officer of the court that your defendant has done something. And after all, this case has been hanging fire for a year now. So I assumed that was part of the reason why it took so long for this case to be resolved, because she needed to do treatment first. So I will accept the party's recommendation. I will order a forfeiture and cost totaling $910, which I note is also a downward deviation from the guidelines. I will order a 6-month revocation of driving privileges. I will order that she complete the intoxicated driver program and that she install an ignition interlock device for a period of 12 months at her expense. Mr. O'Day, have I missed anything?
No, Your Honor, and I just want to echo Attorney Orr's point about the IID being required here, and that also playing into the party's offer and reflecting in the revocation.
Right, and I recognize that the financial burden of the IID is significant, which is why I'm agreeing to the party's recommendations here. Mr. Orth, is there anything further from the defense?
I don't believe so, Your Honor. Thank you.
All right, thank you then. Gentlemen, if there's nothing else, we're in recess on this case.
I have 2 additional ones. Vargas, there was an agreement
Okay.
that she has 2 charges. She was looking
Right.
to reinstate her license in North Carolina, and we have proof of that she did that.
All right, City versus Vargas Guerrero. Mr. O'Day, what's the city's position here?
Your Honor, it appears that the defendant has obtained her North Carolina driver's license, so the city moves to dismiss count 2.
So ordered.
And one more,
And then City versus McNett.
no further, he has a copy of this. That was the agreement, with no further citations for 6 months.
What's the city's position on Mr. McNett?
It appears that he has not received any other citations, so the city would move to dismiss.
So ordered. Which leaves us with Mr. Hammes.
He will not be appearing tonight. He is making a $1,000 payment today. I understand he was not given enough notice. I gave papers to the PD to serve him last week. They didn't get to serve him until 2 days ago. and he didn't think that was enough notice. It was partially my fault for not getting the paperwork to them sooner because I was dealing with personal issues with my family.
No, that's okay. I
so-
understand.
I don't know what you want to do. If he makes another payment, should I get him here in August? But we have a few restitution hearings scheduled in August.
Yeah,
next
but
court.
given Mr. Hamas's track record, I think we need to keep the pressure on.
Okay, and I will get him served
Okay,
sooner then. Okay.
very good.
I have a question off, nothing with tonight, but
Off
just
the
in-
record?
Yeah, well, it can be on the record in general.
Okay.
We have a restitution request for a defendant who received a citation. The other party did not receive a citation. The defendant, who is being summoned to appear for restitution, wants to counter. I've never had that happen.
Wants
I
to what?
didn't know what to say to him. He wants to counter and try and get restitution from the other guy too.
File a
Even though he
motion.
even if he wasn't cited, I
Yeah.
didn't think it was allowed.
That's-
If there's no citation,
that's-
but I wanted to verify.
No, that's, unless you've got a different position, I don't think that's anything that I have anything to do with.
Yeah, if there's.
No, I agree.
Yeah.
Okay, so I will, okay. Unless he wants to get an attorney, I guess that's,
I
okay.
hope he does.
Yeah, that's it.
Makes
That was- I
everybody's
just-
life easier.
That was a new one. I had never been told that, so that's it.
All right, then we're adjourned.
Excellent. Phew.